Typical form of damages is to compensate the person for payment in lieu of notice. So that would be a sum of money that the terminated employee would be entitled to compensate them for the fact that they were terminated. Typically that is based on an estimation of the amount of time that the person would reasonably take to secure another job with similar compensation and similar working conditions. Now, since 1960, the courts have implemented a test called the Bardell factors. And the Bardell factors look at the character of employment, the length of employment before the individual was terminated, the age of the employee at the time of termination, and the last factor would be the availability of other similar employment. Now, those factors are not exhaustive. What I mean by that is the court would be entitled to look at other factors, but those are the main factors that the Bardell principles tell courts and lawyers to analyze to determine what is an appropriate payment for termination, for payment in lieu of notice. And now, in addition to payment in lieu of notice, a terminated employee could be entitled to other types of damages. For example, if the terminated employee was subject to discrimination or harassment, the employee could also seek damages under the Human Rights Code, but by way of the courts for additional damages. Also, for example, the employee could also seek aggravated damages. Now, aggravated damages are paid to an employee to compensate the employee for mental distress that the employee had faced due to the conduct of the employer or the circumstances of the termination. Another type of damages that an employee may be entitled to is punitive damages. Punitive damages are awarded where an employer has engaged in very harsh, high-handed, and sharp practice. It is a different type of damage than aggravated damages. The courts often refer to this type of damage as a civil fine.